All right, well, good morning. I would like to call this meeting of the House and Labor Industry Committee to order. Jonathan, please take the roll.
Dawkins,
Here.
Brennan, Donahue,
Here by designation.
Giroux,
Here.
Green, Haddock,
Here by designation.
Kincaid,
Here by designation.
Krajewski, Mursky, Miller,
Here,
O'Mara,
here by designation.
Scott,
Here by designation.
Siegel,
Here by designation.
Young,
Present.
Grove,
Here.
Anderson, Barger, Bernstein,
Designation.
Cooper,
Designation.
Diorsi,
Designation.
Ecker,
Designation.
Fink, Gleim,
Designation.
Jones,
Designation.
Reichard, Rossi. We have a quorum.
Thank you very much. First, I would like to call up House Bill 1825, printers number 2249, sponsored by Representative Madden. Ryan, please explain the bill.
House Bill 1825, printers number 2249, amends the Pennsylvania Human Relations Act to require employers to adopt written policies and procedures to prevent discrimination, harassment, and retaliation in the workplace. It also requires a Human Relations Commission to develop standardized policies and procedures that employers may use to satisfy the law's requirements. Finally, the bill also creates a Human Relations Training Fund.
Thank you very much. I'd like to recognize the prompt sponsor of the bill, Representative Madden, for brief remarks.
Good morning, Chairman, members of the committee. Thank you for the opportunity to speak on HB 1825, legislation that updates and strengthens the Pennsylvania Human Relations Act by requiring employers across the Commonwealth to adopt written policies and procedures to prevent harassment, discrimination, and retaliation in the workplace. In 2024, Pennsylvania ranked 6th in the nation for reported workplace discrimination cases, according to the U.S. Equal Employment Opportunity Commission. And that figure only reflects reported incidents to the federal authorities. Some studies estimate up to 90% of workplace discrimination goes unreported. The Act already protects individuals from employment discrimination based on race, color, religion, ancestry, age, sex, national origin, familial status, and disability. HB 1825 builds on that foundation by ensuring employers take proactive steps to uphold these protections, not just in principle, but in practice. An EEOC report identified 5 core principles that have consistently proven effective in preventing workplace harassment: committed and engaged leadership, consistent and demonstrated accountability, strong and comprehensive harassment policies, trusted and acceptable complaint procedures, and regular interactive training tailored to the audience and the organization. These model policies and procedures will be made publicly available on the Commission's website and updated as federal and state laws evolve. The legislation also establishes the Human Relations Training Fund, ensuring that financial penalties collected under the Act are reinvested in training, education, and outreach.
Consumers, real people, and driving prices really through the roof in some cases. We all remember the Taylor Swift Eras Tour that occurred in 2022 and the fiasco with that, where the bots overwhelmed the ticket system and left fans paying 50 or 70 times face value. So unfortunately, that kind of digital exploitation's only grown, and the 2022 Imperva BadBot report found that 28% of the global
Will the committee report HB 1825? I will be offering an amendment A01810. Ryan, please explain the amendment.
Amendment A01810 removes vague language and clarifies that the standard policies and procedures developed by the Commission are not required to be used by employers as long as the employer adopts policies and procedures consistent with this Act.
Thank you. The question is, will the committee agree to this amendment? Now recognize the minority chairs for questions on the amendment.
We don't have any issues with the amendment.
All right. So, Jonathan, hearing none, Amendment A01810 is amended into House Bill 1825. Is there any other questions or anyone wants to talk on the bill?
Representative Anderson.
Representative Anderson? On the bill.
Ma'am, you stated that 90% of these are alleged or estimated to go unreported. If they're unreported, how do we arrive at that number?
How did we arrive at?
How would we arrive at that number if they're unreported? That would indicate we don't know about them. So how do we know that 90% are unreported if they're not reported?
Well, I guess in the conversations, when the EEOC did this study, they did speak to people who said, yeah, we don't report it because we're afraid of retaliation.
So,
So they-
it is a completely subjective number according to, it's not a hard data number, that 90%. We're just throwing out numbers because we talked to some people.
No, I don't believe we're just throwing out numbers because we talked to some people and they reported that they do experience discrimination and they're afraid of retaliation, which is why they don't report.
90% of them said that.
According to the study
Of
by
all
the
the people they
EEOC.
talked to.
Yes,
Okay.
according to the study by the EEOC.
I'm not so sure how trustworthy those numbers might be. They seem rather subjective. How many of these reported incidents were confirmed as actual violations that resulted in consequences for the violators?
I don't know that we know that information.
We can get that for you, Representative.
All right, thank you. That's all I have.
Thank you.
Thank you. Go ahead, Chairman.
Thank you. So I've had numerous issues with the Human Relations Commission, so at this point I have zero interest in expanding their power. We've had an executive director, and think about it this way. They're a quasi-judicial entity, right? So when they go in and hold these investigations, it would kind of be like a judge, and this is factually has happened to cases. If you were in court and you had two sides, and the judge goes to this side and says, hey, come here, I'm gonna get a selfie with you, and starts posting online one side of the story, would you say we have fair court case in that case? No. That's what the Human Relations Commission does it. The executive director takes selfies with plaintiffs, people that filing charges. So if you are the other side of that and seeing the executive director, huge conflict of interest, should never happen, should be impartial, doing those kind of behaviors, are you going to get a fair shake? And that's what's occurring with this current administration and the current director. Now, we've had EOC data. Here's actual data from the Pennsylvania Human Relations Commission from their 23-24 annual report. They have had 159 cases at closure. This is between July 1st, 2023 and June 30th, 2024. So they have 159 cases that were closed in 0 to 3 months. 4 to 6 months, 289 cases. 7 to 12 months, 493 cases. That's 27% of all their cases take almost a year to complete. 2 years, 540 cases. That's 30% of all their caseload takes 2 years, up to 2 years to close. 3 years, 251 cases. That's 13.84% of cases are taking 3 years. 81 cases, 4 years plus. Now, the problem with the HRC is they just string this out. So what's the net result? They've had 41 settled after probable cause findings. 211 settled before probable cause findings, which means the business got so sick and tired of the HRC asking for data, increasing attorney costs for them, that they just said, we're settling this. 391 are administrative, which means they were negotiated. 1,176 are non-probable causes. And that's directly from our Human Relations Commission data on their website. So this agency, while designed to protect the most vulnerable, has been an epic failure in administering this program. Delays, costs, and at the end of the day, most of these cases are non-probable cause finding. So nothing to do with your overall bills, but just a frustration from my point as an entity that is taxpayer funded and has gotten large increases in their budget over the past few years, has not done a very good job administering their programs or being effective by any means. There is no reason these cases are taking more than a year to get finalized. So it's imperative they look internally and do some soul searching, particularly if you're getting basically paperwork harassed as a business by this entity, and you have an executive director weighing in and putting their thumb on the scale. How does that look for the employees when they determine reviews and stuff? When the exec director, head of the entity, starts weighing in on these decisions. So I got tremendous issues with the agency. I appreciate the amendment. I think it does improve the bill, makes it a little less innocuous. I do appreciate that. But at this point, until there's tremendous reforms internal, and I urge the governor to have a discussion with that executive director to be more professional and act accordingly and not in violation of current conflict of administration clauses that the executive branch has already adopted and every state agency should be under. There should be no leaning on one side or the other. It's not fair and it's not right, and hopefully they can do a far better job of that. On the individual bill, again, we appreciate the amendment. We think there still has some work to be done on 1825. I will be a no at this stage, but hopefully we can get to a yes as we move forward. Thank you, Chairman.
Thank you very much. Anyone else? Representative Miller.
Thank you, Mr. Chairman. I appreciate the good minority chair. As always, he comes prepared with his thoughts. And there's always something there that makes me pause as well when I try to follow the train of where he's going with it. He did lose me there a bit at the end where he talks about abject failure. That's not what this is. There is no abject failure here with it. There's no doubt, I appreciate when we were talking about where this agency and how it operates over the last 10 years, there's no doubt that we can have real discussions about the timeliness and the patterns as well as how settlements are worked and how just overall the stages of a case proceed. Fine. I would admit that over the last 10 years, most of which I think I've been on this committee with, that I've missed some of those evals that, again, good points to perhaps consider. What I know, though, is that the work that is overall done here is incredibly important into making sure that everyone in our workplace is treated well, treated respectfully, and it's important. When I talk to people who have gone through the process as complainants, I could tell you that they do not feel the failure. I would admit that I have come across a story that talked about timeliness. So again, that struck to me. But I would tell you that what brought them before and why they were there in the first place, and then what they sought at the end, was not a discussion about how an abject failure this is. What by all means, we should be having conversations about how to provide things more efficiently, not an issue. But it's unfortunate in so many ways that we have to have an agency like this in the first place. The goal should be that this is not something that continues, but we're not there yet. And so we're going to have to continue to find ways to make it better, to improve, and to enhance over time, some of which may be something that can be done on a strong bipartisan consideration. But again, I cannot agree with the word choice in relation to this, and so I'm thankful for the amendment, appreciative of the bill, and look forward to voting for it on the floor as well.
Thank you.
Thank you. Any other member? Representative Rossi.
Thank you, Chairman. I just want to comment that I think rural areas have really a lot of small startup businesses, and I think mandates are particularly difficult for those types of businesses, and because of the fine, they're struggling just to get started, and because of that, I'll be a no.
Thank you. Representative Young.
Sure, thank you so much. Chair Madden, I just want to make sure that I'm completely understanding this legislation, it sounds like you are just asking for specific written communication with outlines and defines what is expected for an employee from an employer and vice versa at the workplace. Just clear language that says this is what harassment looks like. Here is the process of reporting, and here's what is the expected outcome, right? Is that?
That is correct. And if it is clearly stated and there is a place that people can go to see the behavior or the treatment that they're getting is clearly harassment, maybe we could improve that 90% of people who don't come forward.
Right, and I just wanted to make sure that I understand, because I don't think this is difficult in terms of comprehension, and I think this is where phonics can be helpful in this space, because comprehension of written language is clear, as I understand it. And so I just wanted for you to reiterate the points that is written in this piece of legislation, regardless of what other talking points are being offered right now. As it relates to this piece of legislation, you're just asking for written, posted communication to be up in the workplace for all to read and understand.
That is correct.
Thank you.
Thank you, Representative Green.
Yes. Thank you, sponsor, for this, your testimony and for this piece of legislation. You know, there are many reasons why in the Department of Human Relations cases are delayed in processing. And I know this because I was a business agent for the labor union that represented these workers. So having a full complement of staff could be an issue that we talk about, and if we wanted to expedite this process. As a labor union business agent for 16 years, it is absolutely true that people do not report incidents of harassment and retaliation because they have to come back to work the next day and they have to face these same people who are harassing and retaliating against them. So it is a difficult situation for a worker to have to come to work and be faced with this, you know, and then they don't have a choice because they need their job. So I support House Bill 1825. I thank you for bringing this to the forefront, and I support you all the way. Thank you.
Thank you, Representative.
Thank you, Representative Barger.
Thank you, Mr. Chairman. So as I understand it, this bill would require posting a policy that would articulate what discrimination looks like, and so as to inform employees, hey, if this kind of behavior happens at the workplace, you got to know that that's discrimination and it's not okay in the Commonwealth, correct? Am I
That's
tracking?
correct.
Okay, so under this bill, and I'm thinking of several small businesses in my district right now, family-owned businesses, run well, treat their employees well. But if this bill becomes law, and please correct me if I'm misunderstanding, it is very possible for a good business that has never had any discrimination happen within its walls, a healthy work environment, respect between management and employees, respect between employees and other employees, could still, because they don't have a policy that lines up with what the government has decided should be posted. If it's not the right policy, or if it's not posted and communicated correctly, they could still be fined, even though they've been exemplary in the way that they've trained their employees and fostered a healthy work environment. Is that true?
No, I disagree. And to be clear, this is already federal law. We're just improving upon it. We're clarifying it to make sure that workers know what their protections
So
are.
if there was no complaint, there wouldn't be any fine under this bill? If no one's complained about a discrimination incident, there's no fine for the employer if the policy isn't posted?
Correct. No, I'm not understanding what you're saying. The policy will
I'll
be.
take another crack at it, and I'm not.
Representative Barger, let Brian have an answer for you.
Yeah, thank you.
So, in addition to the requirements around disclosing prevent that there's a policy that prevents harassment, discrimination, retaliation. They also have to have a complaint procedure and procedure for essentially adjudicating this internally. And then there are fines related to violations of the act. However, unless an employer has demonstrated willful disregard for the requirements of the section, the commission shall waive fines for first-time violations if the employer can prove to the satisfaction of the commission within 60 days that the violation has been cured. They have the ability of the commission to waive the fine for a second-time violation as well.
That's pretty close to what I understood it, so thank you, but thank you for the clarification. My concern with this is that you could still have a business that has had no violation other than the policy isn't posted according to what the law says, and they could receive a fine even though there has been no actual harassment in the workplace. And that, I think, is the kind of policy that scares businesses away from the Commonwealth. And that's not the kind of thing that we should be doing right now. We shouldn't be creating a statute that could penalize good businesses that have in no way violated any discrimination law, and yet they'll still receive a fine. So that's why I'll be a no. Thank you.
Representative Jones.
Thank you, Chairman. The whole premise that a company would hire somebody, pay them a competitive wage and benefits to strengthen their company, only to turn around and harass them, I find highly unlikely in the first place. As I've shared on a similar bill a couple months ago, if a company's foolish enough to do that, employees will leave and go elsewhere, and smart companies will hire them, and the company that's in violation will pay the consequence. Plenty of ways with social media to spread the word about what a terrible employer they are. So yet again, another government solution to a non-existent problem, or one that can easily be addressed through the free market. But the primary reason for my comment, I just can't help but point out that there, at least in our notes here, nobody is asking for this bill. Literally no one. The only group that we have listed supporting it is the HRC themselves, so they can hire 3 more employees at a cost of $275,000 to justify their already inept and largely unnecessary and largely incompetent existence, as our chairman pointed out. My limited experience with them is that they are the epitome of a useless bureaucracy, doing little more than harassing good employers. We have significant opposition from a number of legitimate organizations, so I see no reason to vote for a bill that no one other than the government entity itself is requesting. Thank you, Chair.
Thank you. Chairman Grove, sorry.
For last time. I'm limiting myself.
Okay.
Yeah. So reading through this bill and hearing discussion, so this is already a provision of federal law. So the big question is, are businesses violating federal law to the extent that we need to fine them at the state level? That's question number one. I don't see any data. I don't have any data on employers actually violating this, nor have I heard anything that the employers not having this is a big problem. So 2 goes down to, why are we creating a fine? And I guess the big issue here is the simple fact that the fine goes back to the agency that is letting the fine. So in theory, the agency themselves can fund themselves through violations at $1,000 a time to create an internal pot of money for themselves. Traditionally, if we do fines, it's kind of like allowing the state police to have all of the citations and fines go back to themselves. We don't allow that. That goes back to the general fund, so the citizens of the Commonwealth know that when they're getting a speeding ticket, it is not the state police funding themselves, much like police or other entities. Traditionally, that would go back to the general fund, and then we would allocate out to create a level, make sure we do not have a conflict of interest where the state agency says we're having a budget shortfall, let's get out there and find people to bring revenue in. So one change I think that should probably be made is to have a disconnect within the legislation between the fines and directly coming in to the state agency. There should be a buffer there. It should go to the general fund, and then we can appropriate at time. Just a thought hearing through the debate and rereading of the bill. Thank you, Chairman.
Thank you. Anyone else would like to be recommended?
Yeah, I will.
Representative Miller for the second
I
time.
apologize. Thank you, Chairman. Look, discrimination exists. Discrimination exists. We've been dealing with it. I'm trying to think over my 12 years plus in this body. We deal with it here.
Thank you.
What are we? And the solution, and I'm trying again, try to figure out what the alternatives are, which seems to be go on Facebook and Twitter. I find that to not be acceptable as an answer in 2025, that the answer for a victim of any discrimination is hopefully you get a good pickup on your Twitter hits, right? It's not acceptable, right? And we've been struggling as a body here to provide the environment that makes it so more people come forward. I'm concerned. Look, the 90% I think that was raised and the good gentleman had questioned you about, that's a shockingly high number. It's a shockingly high number, right? And what gets me about it is I don't know for certain if it's 90. I don't know if it's 82. I don't know if it's 91. I don't know. What I know is I keep hearing these high numbers. I keep hearing it. And then when we were sitting here as a body trying to develop our own policies recently on how to make it so the discrimination was addressed better here, right? We talked about ways that we were trying to make it so that people felt more comfortable because our own employees were telling us that they did not feel comfortable to come forward. This is not like a make-believe scenario here. I thank you again, and I know that it's something here that we can ask questions about. I know that we can go into some discussions about how to make the system better, but we can't sit here and say that discrimination doesn't exist. We can't sit here and say that people don't feel afraid to come forward. That comes up, and I know the majority of Pennsylvania workplaces are doing the best we can. We want to applaud those things. We want that. We want to put agencies in relation to this out of business, ideally, is to get to a point where there is no discrimination in the workplace. The problem is, the 12 years I've been here has highlighted, besides anything personal or any anecdotal that comes up, family, friends, people come to talk to you, but the reality of it is here that every one of us who's been here over these past several years know that discrimination exists. It's something that we've worked hard to get forward, to improve upon. So again, thank you for bringing up the bill. I just had to comment.
Thank you, Representative. Thank you for your remarks. And I would just like to speak to some of the other comments. It's not a burden on a company to post what the regulations are, what they should do, how they should respond if they feel discriminated against. Good companies should want to do that to protect their employees, to show their employees, we've got your back. If you feel this way about anything, you can come to us. And that's simply what the bill does. It's not looking to find good companies. It's just asking good companies and everyone to post what the discrimination policies are, to give people an open door to feel like they can come forward, and they can, just to your point that people feel like they cannot report it because nothing will be done. This creates the framework to give an employer and an employee some peace of mind that they're being heard and that the policies protect them.
Thank you. Representative Fink.
We keep hearing this 90% number being thrown around, and Representative Anderson asked about the 90%, but you can throw any number that you want out there, but without the data, we don't know what 90% means. Is it 90% of 3 people that we've spoken to, or 90% of 100,000 people we've spoken to? That makes a huge difference. Do we know the exact sample size of that 90% that we're talking about?
No, we don't. It's a study from the EEOC. It's a study. Take it at its word that it's a study, that it's a government study. And we go by their numbers.
We're taking the word of a government agency. I'd really like to see the actual data, the number that the people that they've spoken to get to that 90%. Because like I said, it's a big difference between if you're talking to 3 people or 100,000 people.
And Representative, we can ask for some data that we can give to the committee.
That'd be fantastic. it'd be great to have it before we're voting on the bill, so we know what we're voting on. But that doesn't seem to happen here in Harrisburg.
Any other member want to be recognized? All right. Oh, sorry. Representative Kincaid.
Sorry, I just wanted to. We tend to do this thing where when we're opposed to something, we say we shouldn't do it because it's duplicative, and when we are for something, it's fine if it's duplicative, which I always find really interesting. But to the chairman's question about why it is that we do this when it's already unlawful at the federal level, the reality is that the federal government does not always pursue these claims. They do not always have the bandwidth to do it. Frequently, what happens is it has to be a larger violation. So having these tools available at the state level allows our state attorney general and our state HRC to address these issues so that if they are, sort of smaller violations that would not raise, the attention of a federal response, that our employees have tools to be able to address this. And, as somebody who has been harassed in the workplace, as somebody who has been in this building where there are a number of stories that you get told coming into this building of who to avoid and who not to be alone in a room with, who should who you should kind of be wary around. I think the idea that this doesn't exist, and when it exists in the halls of Harrisburg, and we have continued to work to address it. To Representative Miller's point, we have to do more, and we clearly need more tools to be able to do it. So, whether or not we consider this redundant, the simple fact of the matter is we are allowing our employees to have more tools in their toolbox to be able to address discrimination and protect themselves.
Thank you very much. All right. Seeing no other members, I just want to thank the members. I want to thank the sponsor for this bill. We hear a lot of different views, especially in this committee, around different policies and positions and how we kind of move forward. The one thing I thought we all could agree that harassment absolutely happens every single day, almost across every industry that we know. And it doesn't matter if you are a low-pay wage worker, high earner, it doesn't matter. We have seen cases where folks have been prosecuted from every level around discrimination, around harassment. So this, to me, seems like a step in the right direction. I think it's a de minimis acts of businesses to post alongside of the other required postings in the break room of what your rights are for this particular act. So I'm going to encourage members to vote an affirmative for House Bill 1825. And with that, Jonathan, you can call the roll.
Dawkins?
Yes.
Brennan?
Yes.
Donahue?
Yes.
Jarrell? Yes. Green?
Absolutely.
Haddock? Yes. Kincaid? Yes. Krajewski? Yes. Mursky? Yes. Miller? Yes. O'Mara?
Yes.
Scott? Yes. Siegel?
Yes.
Young? Yes. Grove?
No.
Anderson?
No.
Berger? No. Bernstein?
Designation no.
Cooper?
Designation no.
Diorsi?
Designation no.
Ecker?
Designation no.
Fink?
No.
Gleim?
Designation no.
Jones? No. Reichard? No. Rossi? No. The bill passes as amended.
Thank you. House Bill 1825 is favorably reported as amended. I would now like to call up House Bill 1826, printers number 2250, introduced by Representative Madden. Ryan, please explain the bill.
House Bill 1826, printers number 2250, amends the Pennsylvania Human Relations Act to expand the Act's protections to agricultural workers, domestic workers, as well as workplaces with 2 or 3 employees.
Thank you. I would now like to recognize the Representative Madden for remarks on her legislation.
Thank you, Chairman. House Bill 1826 strengthens the Pennsylvania Human Relations Act by extending workplace discrimination protections to more employees across the Commonwealth. Under the current law, the Act leaves behind many workers, including those in agriculture, domestic service, and small workplaces with fewer than 4 employees, who currently lack basic protections against discrimination. These exemptions are not only outdated, they are inherently discriminatory. Agricultural and domestic workers were historically excluded from landmark labor laws like the National Labor Relations Act and the Social Security Act, largely to secure political support in the earliest 20th century from the southern states. At the time, a disproportionate number of African Americans, especially black women, worked in these sectors, and the impact of those exclusions continues to be felt today. As the National Employment Law Project testified before Congress in May of 2021, systemic racism stained the original passage of the Fair Labor Standards Act, and it lives on in the exclusions still in place today. HB 1826 removes these harmful carve-outs and lowers the employee coverage threshold from 4 to 2 employees. This is a practical, targeted update that ensures more Pennsylvanians can work in the environments free from discrimination, regardless of the size of their workplace or the nature of their job. Every worker deserves equal protection under the law. I respectfully ask for your support and an affirmative vote on HB 1826.
Thank you very much. Now the question is, will the committee report HB 1826? I now recognize Chairman Grove.
Thank you. So number one, Section 4C1, the definition of casual basis, that probably needs clarified if this bill is to move forward, particularly if it gets signed into law. So occasionally is not defined in the bill. Comparatively long and irregular intervals needs defined in the bill. Limited and temporary purposes needs engaged, and matter of special engagement. I have no idea what that means. That's not defined in the bill. None of those are defined in the overall act. So just from a understanding, both from the employer side and the enforcement side, clarification of what that actually means is very, very important, so we don't miss something that may happen that's harassment, or 2, just clarification for businesses so they can actually abide by the act moving forward. So just some top level stuff. 2, the Farm Bureau is opposed to this, so having discussions with them, I think, would be very important if this bill were to move forward. I would urge everybody to have a conversation there to make sure that we're helping struggling farmers. We need them for our food, et cetera. So the goal is not to put any more burdensome mandates on them moving forward. So this bill limits or reduces kind of the threshold for small businesses from 4 or more down to 2 or more. Again, within this, I don't know of anybody that's actually, quote, asking for this in Pennsylvania. I don't know what the rationale behind doing the adjustment for a small business impact, particularly as we're one of the worst states for entrepreneurship in the entire country. So I don't think that's a necessary provision moving forward. So just a lot of language clarification into just the overarching impact on our agricultural communities. We need to have a sit-down conversation with them before moving this forward. So thank you, Chairman.
Thank you very much. Any other member want to be recognized? Representative Miller.
You know, I appreciate the good chairman's thoughts. You know, I think one of the questions a bit on this is how best can we support farmers? How best can we make it more attractive for people to work there? You, Chairwoman, brought up some of the exclusion language that has sort of plagued certain aspects of this where we have exempted workers from certain rights. You know, this right here to me is a step in the right direction where we're trying to say that, look, we want these jobs to be as good as any job anywhere and hopefully competitively better. But that also means that they should be free from discrimination in the process as well. So I don't know how I kind of get to the point of saying, how can I make work more desirable for people to go do. But I got to make it so that harassment is more likely to occur there, or the protections are not extended there. I also find it a little bit challenging, just in a moral sense, for me to say, look, I'm going to care about harassment impacting workers in one field, but not the other. Right? That doesn't quite, I can't balance that out a little bit either. Right? So I definitely would agree that how we can make agricultural work more desirable, sustainable, how we can work to develop workforces right here in Pennsylvania that can support our farming industry. Great discussions and hopefully things that we could come in commonality with. But again, going to your point of your bill and why I support it is because I can't sit here and say that I would somehow be against harassment in one, but believes that some other workers are not entitled to that protection. In my opinion, every worker in Pennsylvania is entitled to a stronger, supportive, anti-harassment, anti-discrimination work environment so that they can stay, build long-term success there, build a career there, and provide the type of expertise that every employer would want to have. Thank you.
Thank you. Representative Jones.
Thank you, Chairman. Just a quick question for the maker, and this is not sarcastic. Why isn't it just one employee? I mean, if we don't want to harass two, why would we want to or are you assuming that the owner counts as the one? Does the owner count as the employee, or if they had literally, if it's a one farmer with one employee, they do or don't, does or doesn't apply to them?
I don't think an employer would count as an employee. I can share some experiences with you as a 16-year-old employee in a mom-and-pop pizzeria. When mom went to get supplies or things like that, I was constantly harassed by dad. I never reported it. I didn't even go home and tell my parents. It was a job that fit within my schedule as a high school student, and it was paying bills for me. And at that age, I just assumed it was part of the workplace. And so when you talk about the 90% of people who don't report, those are what we're talking about. And women more often than men don't report because we feel like there isn't anyone to protect us. And we're talking about two segments, agriculture and housekeeping, people who have, from the beginning, were not included in this for reasons that aren't fair. So I don't understand why extending these protections to these groups of people would be met with so much opposition, that we're trying to hurt farmers by asking them to put in place practices for their employees. We're not hurting them. We're not creating burdensome restrictions or things for them to undertake. We're just trying to protect people who have historically not been protected. I would dare say that tariffs are hurting our farmers more right now than extra protection for the worker.
No, I appreciate that answer. And in all seriousness, I think your pizza shop example is pretty legitimate. I really do. So you got me thinking there. I think that's a good point. I don't think there's a single farmer in the state looking to Harrisburg for help, so I would challenge the premise that the previous speaker and to some extent yourself said. No one, I'm not sure anybody in the state, any business, looks to Harrisburg and said, please help us out with our policies. But I would say this, I think your pizza shop story is actually pretty compelling. And I would be willing to offer up the following on both bills. I'll not only vote for them, and I'm serious. I mean, we're trying to work together here, because I think it's absolutely disgusting, anybody that would take advantage of a 16-year-old girl, or anybody, but particularly females who are often, to your point, put in vulnerable positions, which is absolutely inexcusable and disgusting. I have two daughters myself, so. I would vote for, co-sponsor, and speak in favor of, and lobby the Senate on both of your bills if you were willing to put in there a consequence for false reporting. So if HRC evaluates, which is the majority of the cases, and finds the claims to be baseless, and an employer has spent thousands, sometimes tens of thousands or more, to be found innocent, then the person making that claim should be subject to at least the same $500 or $1,000 fine. Okay? If you're willing to do that, I will be totally on board, because that's a trade I would be willing to make. I do agree that if you're being harassed, whether it's one employee or 4 employees, the first bill's not terrible with posting a policy. I don't like spending to hire 3 more employees, and to Rep. Barger's point, simply to fine a business for not having a policy posted when they've done nothing wrong. But if we've got bad actors, like the jerk that you worked 4 years ago, I have no issue going after them, but I would like to see some consequence for false reporting, which in my experience, different perspective for sure, I don't know what the numbers are. I don't have any data. But I would suspect at least half, my guess is 80% or more, are disgruntled employees making false claims. If there was some consequence for that, I think we, at least speaking for myself, could find some common ground there. Because I have no desire to protect bad actors, whether they have 1,000 employees or 1 employee. So I do appreciate the spirit of that very much, and I appreciate you sharing your story.
Thank you, Representative. Thank you for your words.
Thank you. Any other member want to be recognized? Seeing none. I thank you, all members. I urge members to support this important legislation. I'm glad to hear that there's the potential of some bipartisan cooperation, which is what we ultimately want to see. So with that, Jonathan, I'm going to ask you to call the roll.
Dawkins?
Yes.
Brennan?
Yes, and all the remaining Democrats will vote in the affirmative.
Grove?
No.
Anderson? No. Barger? Bernstein?
Still me. Designation, no. Sorry.
Cooper?
Designation, no.
Diorsi?
Designation, no.
Ecker?
Designation, no.
Fink? No. Gleim?
Designation, no.
Jones? I'll vote yes. Reichert? No. Rossi? No. The bill passes as committed.
Thank you. HB 1826 is favorably reported as committed, and seeing no other business, this meeting is now adjourned. So thank you.